Hello, everyone. As I'm speaking, I'm going to be logging people in, so please be patient. This webinar is originating from the City of Vancouver, which is founded on the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. Some speakers will also be presenting from other locations today, and we respectfully acknowledge those traditional territories. Hello, my name is Sophie King. I'm the Manager of Professional Learning at PIBC, and I'm very happy to welcome you to PIBC's first Peer Learning Network webinar, Ask a Lawyer. One moment, please. Our program today features Lui Carvello of Carvello Law as the moderator, and our speakers, Bill Buholzer, Associate Counsel with Young Anderson, Don Lidstone with Lidstone and Company, and Janae Enns, also with Lidstone and Company. This webinar is being recorded as usual, and a link to both the webinar recording and the slide presentation will be sent to everybody after the webinar. Finally, a word about questions. We're going to do things a little differently today than our regular webinars. When all our speakers are done presenting, we will then move on to the Q&A portion of our program. In order to answer as many questions as possible, we had asked everyone registered to submit their questions ahead of time. We received nearly 70 questions from people all around BC. And today our speakers will endeavor to promptly answer as many questions as possible. Before we begin, I would like to welcome the PIBC President, Emily Adden, to present the usual President's Minute Update. Emily, could you kindly turn on your webcam and your mic?
Hello, Sophie.
Hello, Emily.
Yes, I'll just take a moment of your time here. I know you have a really full program, and very excited to be able to bring you this first webinar for the Peer Learning Network. I just wanted to mention a few things on behalf of the board in relation to the Peer Learning Network. We had a survey that's just been completed on Friday where we were asking you what your questions are, what your suggestions were, and what you'd like to see in terms of the rollout of the Peer Learning Network. So we're just analyzing the results of that survey right now. But I want to reassure you that we're live to your concerns, and as well as live to the enthusiasm that some of you are showing towards the opportunities for housing as well. So we're speaking and advocating for you at the provincial and federal level. And in fact, I presented at the UBCM Housing Summit last week, and also speaking to CBC News and other media sources in relation to some of the challenges that you're facing. And I know that's a discussion for the next 2 hours, is some of the questions and concerns that you have. Just one more mention, Planning West is calling for submissions on an upcoming issue on housing. So please consider participating in that. And with that, I'll turn things back over to Sophie.
Thank you, Emily. Okay. So now I would like to welcome our moderator, Lui Carvello. Lui is both a registered professional planner and a lawyer who has extensive experience with municipal law and bringing various groups to the table in a collaborative way. Lui has served as a PIBC director since 2013 and has chaired a number of strategic PIBC committees. Lui, please turn on your webcam and your mic.
Thank you for the introduction, Sophie. If everybody can hear me okay, I have the pleasure of introducing our first speaker, Bill Buholzer. Bill's an associate counsel at Young Anderson Barristers and Solicitors and a member of the College of Fellows of the Canadian Institute of Planners. He's the author of the manual that we should all be using, BC, Planning Law and Practice, and he teaches planning law at UBC and VIU. For more than 30 years, his practice has focused on planning and land use management matters, and Bill will be giving our first presentation this afternoon.
Thank you, Lui. Bill, whenever you have a chance, please turn on your microphone and your webcam.
Good afternoon, everyone, and thank you, Lui, for that introduction. The image that you see on the screen is my PowerPoint presentation for a short discussion about community amenity contributions. Sophie threatened to put my photograph up on that screen if I didn't provide PowerPoint slides. And after thinking that over for a few seconds, I realized I probably wanted some other image up there. And so I threw this together a couple of days ago, and as I've been looking at it since then, I realized that there's quite a lot of symbolism in this little graphic, which some of which didn't really occur to me until after I had looked at it for a little while. Community amenity contributions and amenity cost charges are a significant part of the provincial government's housing agenda from last November. And I thought it would be valuable to spend a couple of minutes today just with a bit of an overview of the changes that are on the horizon in relation to these two funding sources. First, a couple of comments about community amenity contributions. Over the last couple of years, there have been a couple of processes, including the Development Application Procedures Review and the Provincial Federal Expert Panel on Housing Supply and Affordability, that have highlighted the role of community amenity contribution negotiations in putting pressure on housing prices and also on lengthening or prolonging development approval processes. So the CAC phenomenon, I think, has been on the provincial government's radar as it has been mulling over policy options with respect to this housing supply agenda. The legal status of community amenity contributions in British Columbia has always been a bit murky, and that is, I suppose, why it ends up being shown on this slide as kind of a gray font. The legislature of British Columbia has never provided a clear statutory basis for amenity contributions, in contrast to, for example, Ontario, where the Ontario Planning Act has always been quite explicit about something called Section 37 agreements, and now succeeded by community benefits charge bylaws, which are authorized in Ontario. But notwithstanding the absence of any clear statutory basis, the use of Part 14 land use regulation powers and equivalent powers under the Vancouver Charter to generate significant municipal revenues has become quite widespread in the province. There are a number of aspects of the bills that were introduced last November that directly or indirectly impact the use of community amenity contributions. The first one I'd mention is the requirement for official community plans and zoning bylaws to provide appropriate land use designations and zoning designations to accommodate a 20-year supply of housing as revealed in housing needs reports. This is really going to remove the bargaining leverage associated with rezonings for residential developments that up till now have been used to secure community amenity contributions. In relation to Bill 44, the government is also requiring changes to low density residential zoning, which will also remove whatever leverage might exist in respect of those kinds of zoning changes. The government mentions in its policy document that local governments will no longer be negotiating for amenities through rezoning processes for small-scale multi-unit housing projects. And as I read that, I wondered really how common it is that zoning proposals of that scale would actually be occasioning CAC negotiations. But be that as it may, the government has simply noted that the pre-zoning of these low-density residential areas would eliminate any CAC negotiations associated with them. Bill 46 is more directly on point. It has a couple of provisions in it that broaden slightly the scope of development cost charges. But the main event in Bill 46 is the new statutory authority for amenity cost charge bylaws. And there are a couple of aspects of those bylaws that I just wanted to highlight. Probably the most significant one and the most significant contrast with development cost charge bylaws is that these ACC bylaws will have to identify specific amenity projects. In some cases, they might be projects serving a particular area of the local government. In other cases, they might be amenities serving the municipality as a whole. But unlike development cost charges bylaws that aren't required to identify specific capital projects, it appears that these ACC bylaws will have to do that. The bylaws will be applicable across the board to all projects in respect of which subdivision approvals or building permits are being issued, except to the extent that there might be local exemptions for eligible developments. In terms of the detail, the legislation requires that the estimated costs of a proposed amenity project be adjusted to take account of any federal or provincial grants, to take account of a municipal contribution to the cost of the project that represents the benefit that the project will have for the existing population. And finally, it has to take account of a municipal contribution in respect of the benefit that the amenity will provide to new development. This is in the DCC world something called the assist factor. Each of these three adjustments of the estimated cost of these projects is provided for specifically in the legislation, rather than, as in the case of development cost charges, simply being provided for in a provincial policy document. In the case of DCCs, the best practices guide. The government's policy guidance in respect of small-scale multi-unit housing mentions that there may be amenity cost charges payable in respect of that small-scale development, which seems to indicate quite a policy shift on the government's part. Those of us have been in the Part 14 world for a while will remember when it wasn't possible to impose development cost charges on small-scale residential projects, but the government's policy agenda has clearly shifted into a recognition that those kinds of projects should be paying their share as well. It's also clear from the policy guidance on transit-oriented areas that it's expected that ACCs will be payable in respect of transit-oriented developments, although there's the usual caution in the guidance document about not deterring development by setting amenity cost charges too high. There's no requirement for Inspector of Municipalities approval of these ACC bylaws, although there is plenty of room for the government to get involved in the detail of local ACC bylaws by way of different kinds of regulations that might be made, including regulations that might actually set a ceiling on the amount of ACCs that can be charged. As far as community amenity contributions are concerned, there isn't any specific reference in any of this legislation, including Bill 46, to community amenity contribution negotiations or community amenity contribution reserve funds or anything like that. In fact, Bill 46 specifically says that it doesn't restrict or affect any other power of the local government that might be contained in Part 14 or any other legislation. to the extent that that gives us any comfort about continuing to operate CAC regimes, I guess it's important to note that there is no statutory basis for the CAC regimes. So to the extent that there isn't any other power in Part 14 that authorizes that, maybe that particular provision I've mentioned isn't that important. Clearly, there's no new statutory restriction on CAC negotiations. As I mentioned, there's simply no reference to it in the legislation. And we know that in various cases, including the case in the city of Vancouver a couple of years ago involving a development in the Yaletown area, the Court of Appeal has observed rather in a neutral way that local governments are using their discretionary power with respect to zoning changes to lever significant amenity contributions out of developers. And that comment was made by the Court of Appeal without judgment one way or another as to whether that was a good thing or not a good thing. The only thing I would mention in closing is that now that we have express authority for this kind of charge in Part 14 and in the Vancouver Charter, if there should ever be any judicial attention to whether community amenity contributions are actually authorized in any way under the local government enabling legislation, the fact that there now is a specific authority for that kind of a charge might potentially have an effect on whether a court would agree that the general discretion over zoning changes authorizes local governments to operate this kind of revenue source. And in that regard, the final point I would make about the little image that's on the screen is that I seem to have used a smaller font to indicate amenity cost charges than I used for CACs. And that, I think, represents my impression that it's going to be a long time, certainly years, before net ACC revenues around the province achieve the same level as CAC revenues have achieved over the last couple of years. I wouldn't expect this to be as significant a revenue source going forward as CACs have been, because it will take quite some time for local governments to organize the information and the material they will need to actually put an ACC bylaw together. So with that, I will turn it over to the next presentation.
Thank you, Bill. I now have the pleasure of introducing Don Lidstone, whose municipal law practice has focused in the areas of local government, governance, finance, land use, and bylaws for decades. He's chaired numerous boards and commissions and published numerous papers and manuals and been consulted on the BC Community Charter as well as other statutes in British Columbia and other provinces and territories. He was designated Queen's Counsel in 2008, now King's Counsel. And if Don gives me the pleasure, I will flip his slides as I did in 1997 in my first law job in the province.
Thank you, Louis. It was always a pleasure working with you on the projects that we had going, and I suspect that there'll be a lot more projects between us over the years to come. Maybe longer for you than for me. I'm retiring in 2039. So I'll be dealing with the issues that have been assigned to me by the PLN folks of PIBC. And those are dealing with small communities, urban containment boundaries, septic and well issues, as well as development permits and a little bit about infrastructure. So let's talk about small communities first. I see that there are a lot of planners on this webinar who are from smaller communities and from rural areas as well. I think there's a fundamental rule that applies to everyone in British Columbia under Bill 44 of 2023, and that is that the one additional unit requirement applies across the board, no matter what you have in place for a restricted zone. And that could be accommodated by way of a secondary suite in the building or an accessory dwelling unit on the same parcel. And so if you have single family zones as restricted zones, then you have a requirement for one additional unit. And that, as I say, can be a secondary or accessory. And that's sort of something that applies to probably, I've counted up 107 local governments that don't have to do a lot more than that. You know, they're under 5,000 population and they have other criteria that would exempt them. But it also means that everybody has to have this one additional unit. There are no additional units like the 4 to 6 additional required if you're not in an urban containment area. So if you have a restricted zone as defined and you're not in the urban containment area under the regional growth strategy, then you don't have to do the 4 to 6 units if your population is less than 5,000. Similarly, if you are in an urban containment area that is established under your OCP, and a lot of places don't have a regional growth strategy or an effective regional growth strategy or one that deals with this issue in British Columbia. But a lot of people have an urban containment area in their OCP. So if you don't have it in the RGS and you don't have it in your official plan, and your population is less than 5,000 in the case of the OCP, then you don't have to do the extra 4 to 6 units. Also, remember that there are a whole lot of statutes and other enactments that apply over and above the new legislation. And so these things supersede Bill 44. And that includes, obviously, the Building Code, the Agricultural Land Commission Act, and the Riparian Areas Regulation. And those will continue to apply and will obviously affect small communities throughout British Columbia. Also, there's if your population of your small community happens to be greater than 5,000 and you have the obligation to pay for policing and so on, then there's still an exemption from the 3 to 6 units if the area is protected under the Heritage Conservation Act, or if the parcel is designated under a heritage designation bylaw as of the date that the Bill 44 came into force, which was December 7th. And here's a really critical one. If the parcel is not connected to community water, it is not connected to community sewer, or is not connected to one or the other, then there's no obligation to go with the 3 to 6 units. I think I said 4 to 6 units earlier. I meant 3 to 6. And also, if the restricted zone happens to be located in an area where the minimum parcel size is 1 acre or more, then you don't have to worry about the 3 to 6 units. And similarly, if the subject parcel is greater than 1 acre, then you don't have to worry about the 3 to 6 units. A couple of more comments regarding the UCBs in British Columbia. So land is subject to a higher density if it's located in one of 3 areas. One is if it's entirely or partly in the UCB that's created by the regional growth strategy. Secondly, if you're in a municipality with a population of 5,000 or more, and it's entirely or partly located within the official community plan UCB. Thirdly, if the parcel is located in your municipality and your population is 5,000 or more. At the UBCM session, the minister was asked, how do we know if our population is 5,000 or more? You know, we're at 49322. How do we determine whether or not we're suddenly subject to all of these requirements for the higher density? And the minister said the statistics, Stats Canada provides the information and the ministry publishes the information on a regular basis. So that's only updated every 5 years, and the ministry interpolates and creates additional information in the meantime. But the minister said it was in relation to Stats Can and not in relation to the amounts that are calculated by the ministry in between years. So you may be able to go with the lower density for 5 years or so, if you're close to the 5,000 limit, if you're relying only on StatsCan. I didn't have a good photograph for the septic and well issues, but the key thing is that the higher density obligation under Bill 44 does not apply to a parcel if it's not connected to water or sewer services. And note that the way Legislative Council draft legislation and the way it's supposed to be interpreted in British Columbia, the word or as opposed to the word and has significance. So it doesn't say not connected to water and sewer. It says not connected to water or sewer services. So if you're missing a connection to water or you're missing a connection to sewer, then the higher density obligation does not apply there. A couple of comments on development permits. You know, one of the big complaints that we've heard from municipalities where there's a lot of character in the neighborhood, a lot of history. I wouldn't say the word heritage has come up, but you know, definitely people are concerned about the character of the neighborhood with, you know, setbacks from the sidewalk and the road and lots of trees and foliage, lots of open space, front yards, setbacks that are accompanied by decent side yards and backyards. And then the buildings having you know, a certain sense of history and charm. You know, think of all these areas where the houses were built in the 20s and the 30s and so on. And that where you have 4 to 6 units or 3 to 6 units, it's going to make a huge difference. Where some lots are going to have several stories higher than what people are used to along the street. And if you use the provincial guidelines, they'll be very, very close to the sidewalk instead of having a front yard. So there's nothing wrong with having development permits that deal with form and character and heritage. There are, as you know, several kinds of DPs where you can designate DP areas, where you can have the authority to deal with form and character, as well as design characteristics. And I think that's going to be critical for a lot of places where they want to have the charm and the openness continued. Also, you know, protection of natural environment with its ecosystems and biological diversity, that's a really important one in the context of climate change, as well as you know, you can have a climate change DP specifically. And then the one to deal with hazardous conditions, which, you know, in my experience these days will include wildfire interface and flooding and other hazardous conditions. In British Columbia, there's a lot of land slough, slide, slippage, and debris torrents as well. Also, you know, you are allowed to have development permits. They're not prohibited anymore in the context of the SSMUH legislation. But if you want to restrict SSMUH at all, and we're trying to call that SMU, but I don't know what you folks call it. But when I say SMU around the office, most people don't know what I'm talking about. But you can sort of limit and constrain SMU, but you have to do it reasonably. So taking into account all these cases that are derived from the Supreme Court of Canada decision that requires your decisions to be reasonable, I think it's important that you have a good staff report that clearly sets out the grounds in good faith for having development permits that slightly constrain or restrict the SMU requirements. And you have to consider the provincial guidelines, and you have to have evidence that your board or your council has considered the guidelines, but you're not obligated to stay strictly within the confines. Gary Penway, a very senior planner in PIBC who was with us on our webinar 2 weeks ago, he's working on some basic zones that you can use for under your zoning bylaw for SMU. He's also working on some development permit guidelines that would allow you to deal with your own sort of criteria that are more attractive, have a lot more character, and are more interesting from a street facade perspective and a community character perspective than what the provincial guidelines would prescribe. Provincial guidelines, to me, when I look at them and apply them on paper, It just looks like a 1955 Soviet block construction of apartments that people still live in over in Moscow. And not attractive, and absolutely obliterating any character that was in the neighborhood. So you can have your own rules, but you just have to have good reasons for not sticking with the guidelines. And you have to clearly identify objectives that warrant your application and your usage of your own guidelines in the context of the Bill 44. And a couple of comments on servicing, and then I'll wrap up, because I think this is important. I've found that since December 7th, when Bill 44 came in, about a third of the municipalities in BC do not have recently updated subdivision and development servicing bylaws. And as you know, the on-site and off-site requirements that are in your subdivision and development servicing bylaws can be triggered by a building permit, not just by subdivision. And you're all well aware of that. The problem is that a lot of these bylaws don't contain the effective triggering provisions. And but most importantly, they don't have the standards or the levels of service that you would really want to have if you're going to have, say, 4 units added to a single family, or 6 units altogether in a transit-oriented area. And as you know, the levels of service are going to be substantially increased if a whole lot of single families suddenly convert to 4 units or more. And fire flow is a big one. Fire flow, when you get a building permit application, obviously the building inspector or the building official has to have a close look at fire flow, and they have to look at fire servicing. They have to look at the standards that would apply to the building if the fire trucks can't arrive within the stipulated amount of time. And all of this needs to be reviewed carefully by your engineering and public works people, and reviewed by council in the context of what potential density might exist in the neighborhoods. So you have to have a look at your servicing bylaw, make sure that the building permit trigger is up to date, and that the offsite things for connecting to sewer and water and doing the works to the center line of the highway contiguous to the property are all up to date, and the standards are suitable for the new patterns of development that are going to happen. For example, you're going to have duplexes or fourplexes with entrances on the front and the side and the back. You're going to have laneway houses. You're going to have secondary suites. You're going to have carriage houses. All of these things may require a review of your servicing bylaw. And then a lot of the MMCD, maybe not everybody on this webinar are up to date on MMCD, but a lot of the standards and requirements in there are not really as up to date as we would need in 2024. And so a lot of municipalities have supplementary specs, and I think those need to be reviewed as well. So Sophie and Lui, that's all I have for this initial presentation. Thank you.
Thank you, Don. I now have the pleasure of introducing Janae Enns. Janae is also a registered professional planner and a lawyer. She has her master's degrees in planning, and she graduated from law school with the very prestigious Law Society of BC's Gold Medal. She spent several years working in local governments, and her legal practice includes planning, development, and land use matters. Go ahead, Janae.
Okay, thank you, Lui. So my brief presentation today is going to be focused primarily on the new small-scale multi-unit housing, or SMA, legislation, with a particular focus on practical advice for when planners are making necessary bylaw amendments. I know Don mentioned he's referring it to as SMU. I've been using SMA, so I guess we're going to see what one prevails here, because I'm going to be running with SMA. And just for those of you that attended the Lidstone Housing webinar, this is going to be a really condensed refresher, but also it's going to have an additional focus on some infrastructure points. Now, we are all likely more than aware, but for the statutory context, the province enacted Bill 44 and the local government zoning bylaw regulation, which significantly amended the Local Government Act with respect to zoning powers. The province also released the Provincial Policy Manual and Site Standards, which provide suggested guidelines for these new zoning requirements. And now a key component to this new legislation scheme is that it mandates local governments to amend their zoning bylaws to comply with these new SMA density requirements by June 30th of this year. So now pre-zoning for these new density regulations is required. As for the density entitlements, local governments must now permit at least one secondary suite or accessory dwelling unit on all single-family zones. And this one additional unit requirement does apply uniformly across all jurisdictions. And local governments must also permit between 3 to 6 units on lands that are located in more urban areas and in defined restricted zones. The restricted zones are single family and duplex zones that may permit suites or accessory dwelling units. And the definition of a restricted zone is specifically defined in relation to a zone where the residential use would otherwise be restricted to. So this definition would have the effect of capturing mixed use zones that only permit those limited residential uses. And it's also worth noting that these new density entitlements must be automatic under the zoning bylaw. They generally cannot hinge on any conditional density rules or amenity schemes. They have to be automatic. Now, the initial applicability of the 3 to 6 units of density is not very clear cut. Dawn kind of went into some of the specifics in the last presentation, but just a brief overview. It's first going to be dependent on whether the lands are in fact in a restricted zone. Then you have to consider the location of the lands, whether they're in an urban containment boundary or in a jurisdiction with a population over 5,000. And then you have to consider the size of the lands and whether they are located near a high frequency bus stop. And all of this is set out now in the Local Government Act and the regulation, which collectively governs where and how much of the SMA density is going to apply. The regulation does set out 2 exemptions that apply to all the SMA requirements. So that includes the 1 additional unit and the potential for that 3 to 6 unit requirement. The first being if a qualified professional certifies that the additional density would significantly increase a hazardous condition, then the lands are going to be exempt. And second, the SMA zoning requirements are not going to apply to lands that are located in transit-oriented areas, as those are now regulated distinctly. And as far as the 3 to 6 units of density goes, Bill 44 did provide some discrete exemptions where it's not going to apply to lands protected under the Heritage Conservation Act. So these are going to be lands with heritage or archaeological value. And it's not going to apply to lands that were already designated under a heritage designation bylaw on December 7th. And it's also not going to apply to land that is connected to both a water and sewer system. And it's also not going to apply to lands that are intended to be 1 acre or larger. If an exemption does apply, the LGA does require local governments to give written notice to the minister after adopting a zoning bylaw that an exemption applies to. So local governments don't have discretion just to leave those lands out of these zoning amendments. They do have to issue a notice to the minister. Okay, and now I'm going to switch gears a little bit and go into some of the practical considerations to keep in mind when making necessary bylaw updates. Under the LGA, local governments must consider provincial policy guidelines related to SMA. Local governments don't have to comply with every single guideline. However, the guidelines are not binding law and they don't require strict compliance. They are recommendations. However, local governments do have to somehow demonstrate that they have reviewed and contemplated the policy manual when they're making their zoning bylaw updates. And this can generally be accomplished by including language in the accompanying staff report for the zoning amendment, or potentially through a recital clause in the zoning bylaw itself that documents that this policy manual has in fact been considered. But if a local government decides to diverge from any of the recommendations contained in the policy manual, the accompanying staff report for the amendments should provide the distinct reasons for diverging. And it's also worth noting that the provincial guidelines that must be considered under the legislation are provided in Part 4 of the policy manual. So there is no obligation for local governments to demonstrate that they have considered other parts of the policy manual beyond that Part 4, which provides the site standards. And the legislation does not vest automatic or immediate rights to the SMA density. The density entitlements will occur when the local government has adopted these necessary zoning bylaw updates by June 30th. So until this time, local government zoning regulations, including density restrictions and density bonus schemes that may apply to SMA developments, are going to continue to apply in their normal course. The new SMA requirements, I recognize, may render some in-stream rezoning applications that are consistent with these density changes unnecessary. And in these circumstances, the applicant should just be advised in writing that their requested rezoning is going to take effect once the SMA density requirements are adopted, which will be happening by June 30th, and then allow them to decide how they wish to proceed. Once the SMA zoning regulations are adopted, it can raise inconsistencies or potential inconsistencies with overlapping bylaw regulations, contractual agreements, and other provincial legislation. As a starting point, SMA developments do not get blanket protection from the application of these areas of overlap. So that means covenants on titles and other local government regulations and provincial legislation, including those that go towards health and safety in the environment, they're all going to continue to apply to SMA developments. And in addition, Section 219 covenants and building schemes can restrict density and remain an option for restricting density in the future. With that said, Section 457.1 of the LGA does introduce a restriction where local governments must not exercise several of their regulatory powers, which is provided here on the slide, in a manner that unreasonably prohibits or restricts the SMA density. And now this restriction does not mean that these regulatory powers are going to stop applying to SMA developments. Rather, there just has to be a sound policy rationale and analysis to justify enforcing the regulation in the circumstances. And so what this also means is local governments can't use these powers to intentionally circumvent the SMA density. That would be found unreasonable. The shift to BRE zoning, as Bill kind of spoke to earlier, impacts local government's ability to negotiate works and services in connection with the rezoning application. The SMA mid to low range densities is also somewhat unique, as the servicing needs are likely going to gradually increase several times its current level. And this is in contrast to conventional large-scale developments where the servicing needs are typically known upfront, and then the developer is required to provide sometimes very significant infrastructure upgrades on a development by development basis. In connection with the new SMA upzoning regime that we're now living in, local government planners may want to start engaging in conversations with its engineering department to consider whether the bylaw servicing standards are adequate for these infill developments, and also to ensure that these standards can be applied at the building permit stage. In addition, planners can also always focus on development cost charges to secure the appropriate amounts for the local governments to complete any necessary works and services in connection with a SMA development. Lastly, SMA developments can raise emergency access and fire prevention issues. The location of accessory dwelling units can make it challenging for emergency vehicle access, and SMA developments are clearly subject to more relaxed fire prevention requirements under the building code, in contrast to a conventional higher density development. So local governments and planners may want to revisit house addressing procedures to ensure that accessory units are named via the primary access street, whether that's going to be a laneway or some kind of rear street. And this is just to ensure that the units can be easily located in emergency situations. Local governments also have authority to regulate emergency access routes. So distinct standards can also be set out for SMA typologies. If an emergency access route is inadequate in certain situations, local governments also have authority to require what's referred to as an access route modification under the building code that could require a sprinkler system. So again, these are all conversations that planners could consider having with the building department. And in closing, this is a novel area of law that hasn't been subject to legal challenges yet, so there's inevitably going to be some uncertainties. But without further ado, I'll hand it back over to Lui for the question period, I believe.
Thank you, Janae. I just want to explain a little bit how we're going to do things moving forward. We've had questions come in, as Sophie mentioned, and we've split them up ahead of time to make them a little bit more manageable. You may have already heard some of the answers in the presentations, but we're going to post the questions just in case there was a nuance or something that needed to be elaborated on it. And I will do my best to post the question in the chat so that everybody can see the fullness of the question. Sophie, are we going to bring everybody online now?
Yes, Lui, could I please ask everyone, Janae, Dawn, and Bill, to turn on their webcams and their mics? Thank
And
you.
while that's happening, I'll just note that I am a planner and lawyer too, but I am not appearing today in my capacity as a lawyer. I am a member of the board member. Thank you for the board, and thank you for those that helped elect me to that. And I very much want to continue in that capacity unfiltered. So I will not be giving legal advice. I'll also qualify that the answers given today are not technically considered legal advice. We always like to say that legal advice should be given in the context and the fullness of the facts and situation applicable to the situation. But what we're gonna try to do is get some of the obvious answers, low-hanging fruit to you, and so on. So let's start with a question for Dawn that speaks to local government exposure to liability should they choose not to investigate potential hazards and risks and use that exemption and simply just upzone is the first part of the question. And then we get into an access egress component to that question. Go ahead, Dawn.
Yeah, so if a municipality or a regional district as a corporation has threshold knowledge of a potential hazard that may result in harm, endangerment to humans or property. That threshold knowledge in the case of a government, and particularly a local government, creates a duty. So we're dealing with common law or case law in this circumstance. And under the case law, governments and local governments in particular in British Columbia have an obligation to do something, to take some action if they have the threshold knowledge of the harm or the danger. And that may come in the form of an engineering report that's prepared by the developer's consultant, or maybe their own engineering report, maybe a written complaint or a phone-in complaint from someone that they think there's going to be a debris torrent or sloughing, or that a road is covered with a bunch of rocks from the hill, or that flooding has started, or any one of these things that can happen in British Columbia, since 90% of our land is in areas that are on slopes or in floodplains or subject to other natural hazards. As soon as you have potential knowledge of a specific hazard, the local government has a duty to do something. And that can be on a spectrum, according to the Nielsen and Kamloops case. It could be as small as doing a prosecution under the bylaw, the regulatory bylaw that applies in the circumstances, or it could be as serious as to get an injunction at the other end of the spectrum, or to do some works in between, or to call in emergency services, or to have the province involved if there's a wildfire. Anytime these things come across the corporation's knowledge, then they have to take some action. And there's no need to go looking for it, but as soon as the corporation at any level, there's a case called Daw in Richmond where just having it in the drawer of one person in the municipal hall means the corporation has corporate knowledge of the potential danger. So just having anybody have knowledge of the risk requires the municipality or the regional board to take some action on that spectrum that we're talking about.
Thanks, Don. I've heard threshold knowledge, but no need to go looking for it. And I know that was a much more complicated answer than that, and I would continue that. The second part of that question, I think Janae spoke to this a little bit with the access egress considerations. I'm just wondering if you had anything further to add. Because Community Charter Section 55 doesn't deal with these situations in this person's question, emergency service personnel.
Yeah, well, obviously, if you're dealing with a controlled access highway or an arterial highway, then that falls under the responsibility of the province. In regard to access or egress risks for properties that may not be able to be serviced by emergency response vehicles, fire rescue, and so on, that's something where you have to, you should have your servicing agreement supplementing the MMCD and your servicing bylaw supplementing the MMCD, as well as the building code, to the extent that it doesn't deal with building construction requirements that are prohibited under the Building Act, and deal with those things in that manner. But you do have the authority to withhold a building permit if you don't satisfy the building code requirements for emergency response.
Okay, next question is for Janae. Would rezoning a hotel strata site to a commercial zone and restricting the use of each unit to under 180 days ensure an exemption from the short-term rental regulations?
No, in my opinion, the rezoning and use restriction described might not trigger an exemption. The short-term rental regulations expressly provides that the Short-Term Rental Accommodations Act does in fact apply to strata-titled hotels. Now, there is an exemption from the principal residence requirement for strata-titled hotels if there is a rental agreement in place that bars the property host from living at the hotel. But apart from that limited exception, if a strata-titled hotel provides accommodation for a rental term of less than 90 consecutive days, it is going to trigger the application of the Short-Term Rental Accommodations Act, where the province could potentially enforce the legislated requirements on the hotel operator. And I would also just keep in mind that there is an inherent risk in rezoning or granting permissions to short-term rental operators where there is going to be inconsistencies such as this with the governing provincial legislation.
Thanks, Janae. Now we're going to bombard Bill with a few questions on restricted zones. Can local governments rezone to remove lands from a restricted zone after December 7th, 2023? And there's a little bit more to that question in the chat window. Bill?
I think the answer is no. The legislation begins to speak, as the Interpretation Act explains it, as of December 7th of last year. And so going forward from December 7th, the zoning power has to be exercised in such a way that those minimum density entitlements are put in place. And the kind of zoning changes that are described in the question would not be achieving all of those density entitlements on the land. So I don't think that's an option.
Second question there was, if an existing zone allows a single family dwelling in row houses, is that considered a restricted zone? And again, a little bit more elaboration in the chat window.
My interpretation of the legislation is that the minimum density entitlements have to be provided for on every parcel in the zone. So the fact that more dense development is permitted on other larger parcels in the zone doesn't really have any bearing on whether the parcel that we might be interested in is in the restricted zone.
Thanks, Bill. That the minimum lot size component of that question was quite important. A third question there, if a zone allows only single family dwelling plus assembly or commercial use, is that considered a restricted zone?
Well, I think Janae's kind of already addressed that. The focus is on what is the permitted residential density in the zone. So if there's any residential development allowed in the zone at all, regardless of what other kind of development is allowed, the focus is on what's the permitted density of residential development.
And the last question on that category, if it already allows for secondary suite or ADU up to 3 units, but under the new legislation will be required to provide up to 4, is it considered a restricted zone?
Well, yes, it is for the purpose of, I think it's the 4th subsection that gets into the entitlement over and above 3 units. That for the purpose of that section, it is a restricted zone.
Okay, we're going to go back to Janae. If a zone already allows the minimum required units, does the zoning bylaw need to implement the ministry site standards from the manual?
No, all that the legislation requires is that the local government consider the site standards in the provincial policy manual when making its zoning bylaw updates. So there's no statutory requirement to implement or incorporate the specific site standards in the zoning bylaw. But with that said, if your zoning bylaw regulations do diverge from those site standards, it is prudent to document some type of evidence that you've considered these site standards and provide a rationale for why you're not incorporating them. And that, again, this can be set out in a staff report just to provide evidence if someone goes to challenge this in the future.
Okay, we have a question for Dawn on that June 30th, 2024 date and what the legislation says versus what the manual says. And a municipality in this case is promoting a gradual approach and whether that meets the legislative requirement of Bill 44. Full question is in the chat.
Right. Well, June 30th is the drop dead deadline for which all the zoning bylaws have to comply. And a lot of councils and boards have been grappling with how that timeline can work for them, given all of the staffing issues and consulting issues. Emily referred earlier to the shortage of planners. It's a crisis. That said, the deadline is June 30th. The minister has made it very clear that there's going to be no extension unless you happen to be one of those communities that gets approved for an extension. So it's the drop dead deadline. Your zoning has to comply by then. Local governments can adopt amendments prior to the date. And I think as long as the zoning bylaw complies with the minimum requirements by June 30th, then a gradual approach is fine thereafter.
We had a question for Janae from villages under 5,000 about zoning bylaw templates and so on. Janae, comments on that?
Sure. So the provincial policy manual does provide recommended site standards for lots requiring that minimum of 2 units, and that is provided in package A of the site standards. So you could always refer to those as a starting point, but again, there's no statutory obligation to adopt those exact standards. Apart from the province's recommended site standards, I know we at Lidstone are involved in a project with Small Housing BC, who is working on creating some template bylaws. And apart from just template bylaws, I know that the province mentioned in one of its webinars that they are working on pre-approved designs for these really low scale density developments that are supposed to be released this summer. But the specific bylaw amendments are always going to be customized in accordance with the local context and policy considerations there.
We're going to go back to Dawn here. With residential zones that permit single-family dwelling with or without a secondary suite is the language used in that community zoning bylaw. Now, do they need to amend their bylaw to mention secondary suite every time they now mention single-family dwelling?
Right, so the construction of the zoning bylaw itself will always be individualized for each community. And there's no strictly correct or incorrect approach for that. As long as the density complies with the legislative requirement under Bill 44 and under the TOA, it doesn't matter if there's a catch-all regulation that allows for secondary suites in connection with the single-family dwellings, or if the secondary suite use is listed in each individual zone. That's a drafting preference for each community.
We're going to go to Bill now with a couple of questions on urban containment boundaries. Bill, the first question refers to the lack of a definition, and but provincial staff have been referring to a common understanding, or should people go by that or take legal input on that?
Well, I think it's significant that the legislation contemplates that there might be a regulation made to define what is an urban containment boundary. I think that suggests that the drafters of the legislation realize that there might be some uncertainty about what exactly that means. The questions that I've been hearing have to do with official community plans and regional growth strategies that have policies about urban containment without necessarily using that phrase, urban containment boundary. There might be land use designations that suggest that on one side of a particular designated area, certain kinds of development is being encouraged, and on the other side of that line, development might be discouraged. Whether those policies and associated maps constitute, for the purposes of this legislation, an urban containment boundary is a very complicated question that would require an understanding of really the entire content of the official plan or RGS to understand what the significance of those terms are in that context. So if there is, if that phrase is used and if there is a map that indicates a boundary associated with the use of that phrase, then it's probably pretty clear that that counts for the purpose of those incremental housing entitlements. But if it's anything short of that, then I'd suggest that the local government ought to be getting a legal opinion as to whether there is or is not an urban containment boundary in the plan or RGS.
Thanks, Bill. And there's a follow-up there that if you do in fact have an urban containment boundary established through your OCP or your RGS, can that be altered in such a way that reduces the expanse of it? And how does the new legislation affect that?
Well, the legislation is always speaking with respect to the existence of an urban containment boundary, just as it's always speaking in relation to the question of population. As populations change, the consequences of those population figures for the density entitlements will change. And it seems to me that as urban containment boundaries change, there will also be consequences of that in relation to density entitlements. It would be perhaps inadvisable to be adjusting UCBs for the purpose of avoiding density entitlements that are prescribed in this legislation. But frankly, I can't imagine any practicing planner engaging in that kind of policy development.
I'm going to post a question for Janae now that we've already had comments in the presentations about development permit areas and form and character. And I was going to skip this question, Janae, but it also mentioned phase development agreements component there. I wondered if you might want to comment on anything related to phase development agreements.
Sure. Existing PDAs, phase development agreements, and development permit areas are going to continue to apply to SMUD developments despite any of this new legislation. So that means that local governments can enter into PDAs and create new form and character DPAs that may apply to residential developments captured under these legislative schemes. The PDAs and DPAs just can't unreasonably restrict or prohibit the SMUD density. So PDAs and DBAs, again, can't be used as a tool to intentionally circumvent these density requirements under the legislation. But as long as there is a sound policy rationale, which there should be, then these tools are still available for planners to use.
We're going to go back to Dawn now for a question about prescribed boards and prescribed class of regional districts.
Oh, you jumped to a whole different section here. Yeah. So
this is referring to section 472 of the Local Government Act. What is meant by prescribed? Yeah, go ahead.
That would be which question number under your
5.1.
Under 5.1, Don.
Oh, down there. Gotcha. Okay.
I was afraid we weren't going to get to everything, so I moved to spew things to a second round of questions. My apologies, Don.
That's okay. I think we may make it because it's only 10 after, and we can go back to those other questions in due course. Anyway, I found it on my cheat sheet here. So I think the short answer, just like Bill adverted to earlier regarding the other issue, is that these will likely be prescribed in regulations in the future. And I use the word prescribed, I think intentionally. Whenever the province uses the word prescribed in a statute or in a regulation, it means that the information that you need to know or the regulating content will be in an order in council or a regulation of the province. And it's a term of art that they use in all of the statutes across Canada except Quebec. And I learned that by mistake one day when I put prescribed in a bylaw, and the Legislative Council got really annoyed at me because you can't create regulations by virtue of a bylaw. It has to be the cabinet doing over in Victoria. So anyway, these are going to be prescribed in future regulations, and then I think Janae is going to speak to other regional district electoral area aspects.
You had a pause there, Dawn, and I hit enter too quickly. Janae, will all regional districts electoral areas need OCPs now?
Yeah, this kind of ties into Dawn's response. Most likely no. What the legislation currently sets out is that prescribed regional districts are all going to be required to adopt an OCP. We don't know what this is going to entail yet. It's going to be set out in the future regulations, which haven't been released. But I did just peek at the province's page, and it says that they're anticipating to release more information on the OCP and housing need report requirements by early 2024. So that should be hopefully coming out in the near future.
Back to Dawn for housing needs reports completed in 2021 or 2022 for electoral areas. Will they need to be redone per the new legislation?
Right. Well, there's no specific answer in the legislation as it exists right now, but as Janae says, that there will be information in the upcoming ministry regulation in regard to housing needs for electoral areas. And so for 2024, it's my view that they will expect the regional boards to update these in the context of the new regulations.
I'm going to go now to Bill with a few questions on transit-oriented areas. By 2024, June 30, 2024, TOA bylaw should be passed and includes map, plan, or other graphic material. It's not clear whether governments are expected to show height density requirements in the TOA bylaw itself, or can it just contain a map? Bill, a longer question there, which I'll ask you to elaborate on.
On the question of the density entitlements, probably not a good practice to incorporate them in the bylaw. Strictly speaking, all that's required is a one-sentence bylaw that designates a transit-oriented area or several TOAs with a map attached to the bylaw that says these are the TOAs referred to in the bylaw. The density entitlements are in a provincial regulation, and in circumstances where it's possible that the province will in the future change those regulations, I wouldn't think it would be a good idea to have the current regulations enshrined in the bylaw, because that will set up a difference that will have to be then dealt with by a bylaw amendment. So it's probably best to leave the density figures out of the bylaw. They have traction where they are already in the act itself and the regulations, and they are automatically applicable. In terms of, I think, in terms of where that, there was also a question about where that designation should be done. It could be, and associated with that, whether there needs to be a public hearing. This is not a zoning bylaw, and it's not an official community plan. It's a one-off bylaw required to designate these areas. So there is no public hearing requirement. The bylaw could be a standalone bylaw. It could be incorporated in the zoning bylaw, or it could be incorporated in the OCP. If you have a municipal code, it could be another chapter in your municipal code. It doesn't really matter where it is, but there is no public hearing requirement associated with it.
There was a couple of follow-up questions there, Bill, that I just posted in the chat. Again, we're going to get you to weigh in now on the TOAs overlapping with known hazard areas.
Well, I guess if it overlaps a known hazard area, that there's an obligation here in the statute to designate the areas. So the legislature has presumably determined that requiring local governments to designate the areas is, from a policy perspective, quite all right, even though there might be all sorts of conditions in those areas that make them inappropriate for development of that density. So that policy approach presupposes that there are ways to manage those location-specific limitations, and indeed there are. Development permit area designations, the authority of the building official to require some sort of hazard assessment before issuing a building permit. All of those regimes remain in place.
Thank you. Next question was for Janae. How do the new, I think you said SMA, or SMU, you're a SMA person, requirements work for secondary suites and ADUs used for parcels that do not conform to the minimum site requirements in the zoning bylaw?
Right. The SMA legislation does set out specific lot sizes to determine the density that must be allowed when making those updates to the zoning bylaw. So if there is conflict between what the zoning bylaw says and what the SMA legislation says with respect to lot sizes, then the zoning bylaw might need to be amended to comply with these new minimum site area regulations. So, for example, like the SMA density requirements set out that density between 3 to 6 units that in part can vary depending on the size of the lot. So if the lands are less than 280 meters squared, for example, then the 3 units might be required. But for bigger parcels of land, additional units could potentially be required under the SMA legislation. So you would just have to confirm that the zoning bylaw meets the lot size requirements as set out in the legislation.
So Dawn, I'm going to throw you another little curveball here in that I grouped a couple of the questions under part 7 of there that were intended for you. Where there are existing very small unserviced lots in a regional district, will zoning have to be changed to allow secondary suite or ADU, even if on-site servicing can't accommodate the additional density?
Yeah, that's a great question. I think, you know, the lands are subject to the additional 1 unit requirement in any event. It applies across the board. The inadequate servicing exemption only applies to the 3 to 6 unit requirement and under SMU. And however, if the infrastructure is likely to result in health or safety risks as a result of increased density, as Janae mentioned earlier, you can apply to the minister for an extension to the June 30th deadline.
Okay, and there's a follow-up there about land serviced by community water systems where there's no capacity for new connections. I think you've probably answered that, but go ahead.
Yeah, I think that's the same answer would apply to that situation as well.
Okay. I'll then move on to a question for Janae here. Well, SMA for you, regulations apply to neighborhood level sewage systems operated by a regional district, but only servicing a small group of homes.
Yeah, the exemption for the SMA density for that 3 to 6 unit requirement is specifically worded for land that is not connected to a water or sewer system provided as a service by a municipality or regional district. So here, since the sewage system is provided by the regional district, it's not going to trigger that exemption. So the SMA requirements would apply. That is an unfortunate situation, and it potentially might be a circumstance where the local government could consider writing to the minister for an extension, because there is that authority to apply to the minister, as Dawn mentioned, if there is significant infrastructure constraints that might result in health and safety risks.
Okay, and fascinating question coming up. Speaking to site viability issues, would the local government be responsible to make sites viable for the permitted density? Would they have to buy them out otherwise? Janae, do you want to go ahead with that one too?
Yeah, I think the short answer is no. Local governments are not responsible to make sites viable for these new density entitlements. All that's required under the legislation is for local governments to amend their bylaws to permit this new SMA density. So it doesn't mean that these developments have to be feasible in every situation across the board. It's still going to be very much open to landowners and developers and subject to those areas of overlap with provincial legislation and other local government regulations and even contractual agreements on title. So again, there is no obligation for local governments to acquire lands that are not suited for the legislated density or acquire them in any way.
Thanks, Janae. So I'm going to go to a series of questions for Bill now on covenants. The first has to do with covenant restricting density to 1 dwelling unit per parcel. Can the owner challenge these covenants now and force the additional density?
Well, there is a procedure available under the Property Law Act for someone whose property is charged by a restrictive covenant to apply to court to have the covenant modified or discharged entirely. I would expect that if it's a covenant in favor of the local government, the owner's first recourse would be to ask the local government, now that it has changed the zoning, to allow more density on the parcel than is permitted by the covenant, whether the local government wouldn't like to release the covenant. And some local governments might say yes, some might say no. If they say no, the owner can apply to a judge to have the covenant modified or discharged. And one of the grounds on which a judge might order the covenant modified or discharged is that it's obsolete. And obsolescence in relation to a land use covenant will be, that analysis will be impacted by what the zoning allows. And a judge might be persuaded that the covenant is held by the local government is obsolete because the local government has changed the zoning. How that might play out, I couldn't predict, but there is a process there. And I think clearly the fact that the zoning is having to be changed is going to affect, first of all, whether local governments want to continue to hold those covenants. And secondly, it might affect whether a judge might think they ought to be modified.
Now, Bill, as a little follow-up there, when we're talking about local government there, we're talking about council passing a resolution or the board passing a resolution or somebody who has perhaps delegated authority as opposed to planning staff deciding that these now all should be disappearing. Is that right? I'm
sorry. I was trying to read the question while you were posing it. Maybe you better.
Sorry, that was a different question. We'll come back to the different questions later, because I just heard you say local government repeatedly, and I just wanted to highlight that when you say local government, we're talking about the official decision maker, not planning staff deciding that, oh, I'm just going to now sign all these discharges, right?
Mm-hmm. Okay.
Right. So the follow-up question was, can local governments require covenants preventing subdivision on properties that allow an accessory dwelling unit?
Well, so far we are not into provincial policy reaching into the jurisdiction of approving officers. So if there's a situation where an approving officer is being required to deal with a subdivision application and the approving officer knows what the permissible density is under the applicable zoning on all of the proposed parcels, the approving officer might be of the view that it's against the public interest to create parcels that have those kinds of density entitlements, given the proposed parcel areas, suitability for septic fields, whatever the criterion might be that they're concerned about. And that analysis could, in my view, result in a requirement for a covenant to be placed against one or more of the parcels that are being created that would limit the density of development to something lower than what the zoning allows.
So the third question in this category was about forest, riparian, or generally conservation covenants and the future of those for municipalities. Any thoughts on that?
Well, I think as many of these other kinds of restrictions, those options continue to be available as long as those powers are exercised for bona fide purposes.
Okay, Bill, I just wanted to give you a heads up. I'm going to come back to you on some of the strata questions that were grouped here originally, but first I'm going to go to a different set of questions with a question for Dawn under category 9 of our previous discussion. Do municipalities have the authority to set limits on maximum limits on amount of parking, either before or after the legislation?
Yes, they do. Absolutely. You have a number of communities in the States and Edmonton in Canada that have provided for maximum limits on the amount of parking. Bill 47, one of the gang of 3 that we're all dealing with today, Bill 47 actually prohibits residential parking in the transit-oriented areas, other than if you're dealing with disability parking.
I have another parking question, this time for Janae. Will Bill 47 removing residential parking minimums? What is your take on visitor parking? Can there still be visitor parking requirements?
Yeah, as far as residential visitor parking goes, I don't think that cities can require this in TOAs. The legislation expressly prohibits local governments from requiring off-street parking spaces for residential use in these transit-oriented areas. The legislation does provide, as Dawn mentioned, a really limited exception to this, and it's just for disabled persons parking. So beyond disabled persons parking, there are no other exceptions under the legislation that would allow for residential visitor parking in TOAs. So that requirement, in my opinion, could be subject to challenge.
So Bill, I'm going to come back to you on the question about the local government officials acting as a qualified professional regarding development in hazard areas. Can they do that? What's the considerations involved in doing that? Does the QEP report need to be from a third party?
No, it doesn't. The criterion is simply that the person who's providing the information has the appropriate academic qualifications and professional memberships. It doesn't matter if they're an outside consultant or somebody in-house.
Okay. Now, we had some questions back to Janae on CACs and ACCs. We had a little bit of discussion already on this, and now we just had some direct questions from our planners that asked, can we continue to negotiate CACs from developers until an ACC bylaw is in place?
Yeah, I think Bill spoke to this a bit in his presentation, but the ACC scheme does not replace or void the ability for local governments to negotiate and collect CACs in connection with the rezoning. So that can continue to occur until an ACC bylaw isn't in place and also after. Do you want me to address the second question there too, Lui?
If you'd like to, I think we kind of had some discussion of that, but if you had anything to add, go ahead.
Yeah, just again, CACs are a murky area because there's no statutory authority, as Bill mentioned, but I did dig into the Hansard for the legislation. So the Hansard is the legislative debate, and this exact question was posed in the legislative debate. What's going to happen to the CAC schemes after this legislation, this ACC legislation, isn't passed? And the Minister of Housing very clearly said that CACs can continue to be an option for local governments. This new ACC scheme is just another tool that's available for financing purposes and collecting amenities.
Okay. Have a question for Dawn. If a zoning bylaw already includes wording related to charges associated with the development of additional units over a base number of dwellings in the zone, does this requirement need to be removed if additional units must now be allowed under the new legislation? I jumped ahead again, Don.
Yeah, well, I think we all have learned now that the smooth density cannot hinge on conditional density rules or density bonus schemes. And the province has reinforced that time after time at their sessions. The smooth density has to be automatic under the zoning bylaw. There's one minor exception, and that's where you're dealing with the sixth unit in the TOA near high frequency bus stops. And in that case, that can be conditional on providing either affordable or special needs housing. And other than that limited exception, the density has to be automatic and not conditional and not subject to a density bonus scheme. So under the zoning bylaw, the base density would be smooth, and there could be conditional density rules for any density or units that exceed the smooth requirements, which would be fine.
Okay. We're going to have a few questions for Bill now on public hearings. If a local government chose to adopt a new zoning bylaw as opposed to amending their existing bylaw, are they prohibited from holding a public hearing?
The criterion for the application of the prohibition is whether the sole purpose of the bylaw is to comply with these density entitlements. So if it's a whole new zoning bylaw, then it doesn't seem to me that the prohibition would apply.
So they'll have a public hearing. How does, or maybe what we should be asking is, should a local government try to ensure that public comments are limited to those aspects unrelated to the SMU requirements?
Well, I question whether that would be a practical solution, even if there was a point to attempting it. And I don't think there is a point to attempting it, because I don't think the prohibition applies.
Follow-up question under this category: if a rezoning involves land uses other than residential, but the residential floor area exceeds the floor area of all other uses, will a public hearing be prohibited?
Well, I think all that counts, and this is, I guess, the more general prohibition on public hearings that we're talking about here, all that counts is the floor area. It doesn't matter if there are other areas of the parcel that are used for non-residential uses. It's all about building floor area.
And the next question on public hearings has to do with, are they required for transit-oriented areas as required by Bill 47? Does it make a difference if it's a standalone bylaw versus a zoning bylaw? And I think you started to refer to this previously.
Yeah, I mentioned earlier that these are not zoning bylaws. So whether they're standalone or amendment to the zoning bylaw, there's no public hearing requirement.
Now, this next one, we're getting lots of these days. I'm sure everybody is getting this question a lot. When is a public hearing not a public hearing? And I think what we're getting at here is the procedures bylaws and the public input section of procedures bylaws, and this fear of de facto public hearings. And are people, how does this work when you're prohibited from having a public hearing on when your procedures bylaws allows public input at your normal council meetings? Comments, Bill?
Yeah, I have actually thought more and more when these questions come up as to who would complain if there was a public hearing held when the statute prohibits it. It might be kind of an interesting theoretical question that's been posed here, and that a lot of us have been racking our brains about, because what's the harm? But I guess we have to come to some sort of legal conclusion. And as you mentioned, there are council procedure bylaws and board procedure bylaws that seem to entitle members of the public to come to a meeting and actually speak, even though they're not an elected representative, a member of the council or board, speak about any matter that's on the agenda. So we know, even when a public hearing is prohibited, that there has to be a notice published before the first reading of the bylaw, which is going to look an awful lot like an invitation to come to the meeting to speak about it, whether that's what the notice says or not. I think that there are factual circumstances where, if it mattered that a prohibited public hearing had in substance occurred, that allowing a member of the public to speak at a council or board meeting about the merits of a zoning bylaw, for example, in respect of which there's a public hearing prohibition, that could be a problem. I've noticed that some of these procedure bylaws currently mention that while there's a general right to speak to a matter that's on the agenda, if you essentially book a time ahead of time or notify the corporate officer or whatever, usually there's an exception where the matter that's on the agenda is a bylaw that has been the subject of a public hearing. And that's in the bylaw because the local government knows that it's procedurally unfair to allow one party or another to speak to a bylaw after the public hearing is closed. I've been thinking that it would be perhaps a good idea to consider adding to those procedure bylaws a provision that also eliminates presentations from any member of the public on a matter in respect of which a public hearing is prohibited by the statute, so that the person presiding would be in a position to, first of all, not put the person on the speakers list if that's what they intend to speak about, or secondly, to actually interrupt them and ask them to stop speaking about a particular matter if it's a matter in respect of which a public hearing is prohibited. Those are preliminary thoughts I think that I have on the topic, but I do wonder whether anybody cares that there has been a hearing in respect of something that is not permitted to occur. And just to share a couple more thoughts on that, I think it's remarkable across the province how attached local elected officials are to the public hearing process. Even though they for many years had the right to waive a public hearing or proceed without a public hearing, they haven't taken the province up on that. They've continued to hold these hearings. And I suspect that the legislature in enacting these prohibitions were thinking that local governments wouldn't mind these prohibitions being in place because they don't have any choice but to enact these bylaw changes that the province has decreed must be enacted. But I'm finding that local governments are expressing some interest in actually holding these public hearings, even though they have no choice but to adopt the provisions. They're just that attached to the idea of public process. So it's just an interesting dynamic as to what's going on right now as we consider these matters.
Well, we challenged me to not have commentary and not make faces while people was talking and so on. But I saw us all smiling at certain points of what you were saying there, Bill. And I'll just simply add at this point that the BC Law Institute is consulting right now. I find the word consulting funny in this context, on a paper that they're doing called Renovate the Public Hearing, where they're basically advocating for doing away with the public hearing, or at least that's what one of the members who was giving a presentation said they had already accomplished on. So I'll invite people to look at the BCLI's paper on Renovate the Public Hearing. So Bill, on the series of questions, I'm gonna come back to you before moving on. Who will decide whether rezoning is consistent with the relevant official community plan, thus resulting in the public hearing being prohibited?
I presume that means as between the elected officials and the staff who's going to decide. Ultimately, it might be a judge who has to decide.
Yeah.
But as between the elected officials and the staff, I have always thought that it's a judgment call that ought to be made by staff, or at the very least, there ought to be a very strong recommendation from staff. I think as with such matters as interpreting the scope of a permitted use in a zoning bylaw, it's inadvisable to get the elected officials weighing in on that question, because they're inclined to pay more attention to whether they think the use is a good use to occur in the zone or not, rather than what the bylaw actually says. And similarly, with regard to questions of consistency, elected officials, many of them will be inclined to consider the question of consistency based on their attitude towards the development in respect of which the question has arisen, rather than what the official community plan actually says. So exposing these judgment calls to the political arena, my sense is that's not an advisable choice. I recognize that there may be some jurisdictions where elected officials insist on playing that role, but it's something that I think professional planners certainly ought to discourage.
Now, Janae, I'm going to come to you for a question that is general in nature, but the recent legislation has highlighted a little bit more about what happens when a council rejects, presumably a rezoning application that is compliant with the official community plan. What's the process? What recourses do the applicant have, and what reasons would justify a council rejecting an OCP compliant application?
Right. I think as a starting point, at least, a rezoning application is always going to be at the discretion of council or the regional district board. So there's never going to be an obligation to adopt or approve a rezoning application. But with that said, council or the board, they do have a duty to assess such applications in the public interest. So they can't just reject it for irrelevant grounds, which would be called bad faith. As far as recourse goes, if a rezoning application is rejected, the applicant can always reapply, or it's open to them to apply for judicial review and have the matter heard in court. As far as reapplying goes, typically the procedure bylaw sets out a time limit where if an application is denied, the applicant can't reapply within a set time frame. So usually that is something that's set out in the bylaw.
I'm going to go to a question for Dawn here. Can council turn down a smooth zoning bylaw amendment where it is a requirement from the province?
Well, up until June 30th, 2024, council can turn down an application that is a smooth requirement under the legislation. But after June 30th, there's no discretion on the part of a council or a board to bar that density under the zoning. Not sure what benefit there would come from turning it down, because it's an automatic requirement from the province as June 30th. And I guess some municipal mayors have made public comments that they're not going to adopt it. They're going to wait for the province to shove it down their throat because it's not something that their community is supportive of. My concern about that is that's all very well politically, because as you all know, what can happen is the minister can give you a notice that you have to have your zoning bylaw consistent with the June 30th SMU requirement within 30 days. And if you don't follow up and take the action required by the minister in their scary letter, then you absolutely have to worry about cabinet authorizing the minister to enact an amendment that would apply as if it were a zoning bylaw in your community. In other words, they can supersede council's jurisdiction and discretion and require the June 30th smooth density requirement by way of a unilateral act of the province. And like I say, some mayors are saying, "Oh, that's fine with us. We can be like Alberta in relation to Trudeau. Just do it to us, but we're not going to do it ourselves." Problem with that is that the province will use the provincial guidelines. And as you know, only one part of the guidelines is not discretionary. And all the guidelines don't have to be complied with if you have good reasons for not complying with them. And their guidelines are very, very basic, and they don't create a comfortable community that has character or that reflects the history of the neighborhood. So those provincial guidelines are very negative, and you don't want to end up with a provincial bylaw in your community.
I'm going to go back to Janae for a question that's a little bit more specific. In a community smaller than 5,000 that has OC policies encouraging higher density, can council turn down a zoning bylaw amendment that is similar to small, where we can't have a public hearing because it complies with the OCP? This questioner is assuming they can, provided the decision is fair and reasonable. Janae, comments on that?
Yeah, this kind of ties into my previous response, but council has full authority to reject a proposed zoning amendment for a SMA type development, particularly since those legislated density requirements don't apply in this situation. There could be a multitude of policy reasons for council to turn down such a rezoning. There could be environmental concerns, hazardous concerns. So there are a number of policy grounds that council could consider. It doesn't just have to be on specific density reasons. So council, again, always has discretion to reject a rezoning application.
Okay, I'm going to go back to Dawn with some questions about in-stream applications. I've grouped a couple of them here, Dawn. First questioner was asking, I'm confirming that for all areas, not just TAOs, if a rezoning has already had first reading, then the old process is still to be followed. And then the follow-up general questions, how should local governments deal with in-stream applications?
Yeah, if they've had first reading, then they're in stream, and they're kind of I use the word grandparented instead of grandfathered nowadays. But the old process would still apply in that regard, not just in relation to the TOAs.
Janae, jumping back to you here, Bill 47 appears to fetter council's rezoning authority in that it prevents applications from being refused for reasons of height or density. If this is true, our council is also prevented from refusing applications on the basis of parking, given the minimum parking requirements will no longer be permitted in TOAs, transit-oriented areas. Or is the prohibition on setting requirements distinct from decision-making authority?
Right. So since local governments are prohibited from requiring residential parking in TOAs, an application in a TOA cannot be rejected solely on grounds of parking, since parking regulations cannot apply to that particular development in any event. But as far as fettering council's rezoning authority goes, that is correct. Bill 47 does essentially bar a local government from rejecting a rezoning application based solely on the density and height of what is proposed, if what is proposed is permitted under the TOA legislation. However, local governments can still reject TOA applications on other policy grounds. They still have full discretion to do so, but as far as parking goes, since they can't actually enforce a parking requirement on this development, I would not see that being a viable policy ground to reject an application for.
And I see you added some additional insights, so I threw in your next question there, Janae, and just want to leave it open to you if you had any additions to add for what was a similar, but though slightly differently worded question. Guy says the local governments can turn down rezonings for reasons other than density, such as preservation of heritage buildings, or instance. And what insights did you have on that?
Yeah, that's right. Local governments can reject rezoning applications in TOAs for reasons other than height or density. If, again, what is being proposed in the development is permitted under the TOA legislation. But local governments can consider heritage preservation, environmental concerns, servicing constraints, all the wide range of policy issues that planners should be considering in a rezoning application. Those can all be taken into consideration for these rezoning applications in TOAs. The province also made it expressly clear in its webinars that there's no obligation for local governments to approve every single rezoning that complies with the TOA density minimums, because there could be competing policy reasons to reject such applications.
Okay, I'm going to go to Bill about the housing needs reports. And there was a question referring to housing needs reports in villages under 5,000. Have any regional districts proposed to take this on as a regional approach for the 20-year new requirement? And then we talk about engineering firms and some support, Bill. I know that these are non-legal questions, but if you had some legal commentary about this, I'm sure people that would appreciate that.
Yeah, I didn't really see much sort of legal content in this question. I think that there might be some regional districts that would be engaging consultants, for example, to do housing needs reports for a number of different electoral areas or even municipalities within their boundaries. That's just kind of a maybe more a question for the consulting world to answer than a lawyer.
Let me come back to you with some legal questions on stratas that I had skipped earlier, and basically dealing with stratas and special considerations for small proposals on bare land strata lots. Any comments about that?
Right. As a general rule, I think it's best for local governments to stay away from having anything to do with monitoring or enforcing compliance with private arrangements like restrictive covenants, statutory building schemes, strata bylaws. Those are private matters. My advice is always keep your eye on the ball, administer and enforce public law requirements like arising out of the building code, the building bylaw, the zoning bylaw, and leave those other matters for private parties to deal with.
One of the other questions I skipped earlier, Bill, which I'll come back to now, is the housing agreements. Do you have any comments about what the new legislation means for housing agreements?
I don't think it means anything for housing agreements. A comment that I think could be made in relation to phased development agreements, housing agreements, other contractual arrangements is that the government knows how to terminate private contracts. It has done that with land use contracts, for example. So if they were of a mind to deal with private contracts like covenants and building schemes that restrict the housing densities that they are seeking under these bills, they would deal with that expressly. And they haven't done that, so we infer from that they're, for the time being, content to let these other kinds of restrictions operate.
And I presume nobody else wants to comment on when we hear the ministry answer that same question in the context of those covenants are on our radar screen. So with that, Dawn and Janae, and we had some questions about heritage. I'll leave it to you two to decide these questions about heritage that were going to be our last set of questions, which should bring us right on time here. How can local governments address heritage properties and incorporate local interests?
Okay, I can address the first one. There is an exemption, as we've discussed, under the SMO density for lands that were already designated under a heritage bylaw on December 7th. There's also an exemption for lands that are protected under the Heritage Conservation Act. So depending on the nature of the heritage property, this could potentially be engaged. But there is nothing in the new legislation that prohibits local governments from designating and protecting heritage properties in their normal course. Local governments just can't use these regulatory powers, again, in a manner that unreasonably prohibits or restricts these new density requirements. And I kind of got into the second question there. Should I just continue with it and Dawn can take the next one?
Sure.
Okay. There's also a new prohibition from entering into heritage revitalization agreements that restricts applicable SMO density. So that is something, depending on the circumstances, the planner dealing with the file might want to look into more. But apart from this prohibition, as long as there is a sound policy rationale, local governments can generally continue regulating heritage buildings in the normal course to incorporate those local interests and values. But this is an area that you should consider on a case-by-case basis to decide what particular regulatory power is best to achieve those objectives, and also just to get a better sense of the legal risk in exercising those regulatory powers.
Dawn, did you have anything to add on the last question there? How should municipalities deal with pressures to deregister and de-designate?
Well, there'll always be those pressures based on the new legislation, but there's nothing in the legislation that requires local governments to deregister or to de-designate heritage properties. In fact, in my view, it does the opposite. It provides exemptions for properties that are designated for heritage protection. Therefore, whether the council or the board wants to undesignate a property is entirely a policy decision in the full discretion of the council or the board. There's no statutory obligation to do this.
Thank you. So now we're coming to the end of our presentation. Our first set of questions here, we have and so I'm just going to leave it open for any of you or all of you if you had any final thoughts in 30 to 45 seconds or so. Bill, let's start with you. Any final thoughts?
No, other than to say those were interesting and challenging questions that people put forward, and I kind of wish we had more time.
And I anticipate this won't be our last, it's our first, but it won't be our last session. Dawn, any final thoughts?
No, to be honest, I found all of these questions from the planners from across the province to be extremely astute and practical and sharpened. Whereas when we're dealing with the elected officials at the UBCM sessions, Emily can comment if she wants. the questions were more along the lines of, do we have to do this, and how can we get around it? You know, I think we all have to dig in now and actually proceed to make this happen. One last thing I'll say is that in our webinar a week and a half ago, we did provide 3 detailed pages of next steps, and it's quite daunting. All the things you have to do right now, plus the things you have to do by June 30th, plus the things you have to do by December 31st, 2024, and January 1, 2025, and thereafter. And so we're going to, we've mailed that out to all the people who attended our webinar, but obviously it's clear that there are a lot of people on this session that weren't there. So we're going to put it on our website and make that information available along with the video of the webinar.
Janae, any last thoughts for you?
Just that I sympathize with all the planners that are having to implement this legislation. First, there's a very tight timeline, and this is a novel area, and it's very substantial changes. And so I recognize there's a lot of uncertainty, but I think forums like this and information sharing are doing a really great job in trying to at least collectively address some of these ongoing questions and uncertainties. And I'm optimistic it'll keep getting clearer as the days go on, with the province also releasing more information every week. So yeah, keep plugging along.
Sophie, at this point, I think I'll ask you to put on our final slide because it has the link to PIBC's PLN page. And I'll conclude by thanking, first of all, our distinguished panel of speakers. You know, I didn't mention it because I didn't want to be too personal at the beginning, but I had the good pleasure of teaching Janae planning law at VIU, and I had the good pleasure of Bill signing my logbook back so that I could become a planner in 2003. And I already told you about my slide turning for Dawn years ago. But it's not about me, but I want to tell you what the board is doing. And you'll see some of the things that are at the PLN webpage there. We have made arrangements to make Quick Scribe available so that all the planners have easy access to the legislation. So if you haven't taken advantage of that, please do. If you don't already have that through your organization. And you can do little word searches for like December 7th and November 23rd, other key dates and so on, so you can see what exactly the new legislation is there. BC Planning Law and Practice, the board thankfully approved a motion to facilitate getting that out to our members, because we know not everybody has that, and it's quite daunting, the cost of it. So we've made arrangements to get it at a reduced cost, and PIBC will subsidize some of those as well, even further. So that's not on the website yet. We're making arrangements to do that, and we're going to make sure that that coordinates with the update that includes the new legislative provisions as well. And other than thanking everyone for attending, I saw that some more questions came in. Keep them coming. We will make note of them and move on. Sophie, any last words?
Thank you, Lui. I just wanted to say thank you to all our speakers. That was an incredible presentation, very thorough. And actually, if you don't have a legal background or a planning background, it's quite entertaining and interesting. So thank you for putting your presentations in a very simple way that anyone could understand. And thank you, Lui, for great moderating.
Do I dance now, or
well, we'll call it a webinar, and I'll leave the chat window up a little longer in case anybody can think of any questions. Please type them in the chat window, and we will tabulate them and address them at a future date. So your questions will not be ignored. We will address them perhaps at a different webinar or in some other capacity.
So for those in our northern chapter, we have a lunch and learn on February 29th, and PIBC will be rolling out regional sessions across the province to advance our PLN, both online and in person. We're going to be doing that through our chapters and so on. So we look forward to hopefully providing some assistance for everybody.
Okay, great. Thank you all. We'll say bye for now. Much appreciated.
Thank you, Sophie. Bye.
You're very welcome.